Koinange Live I'm Jeff Koinange, and we're indoors inside the Intercontinental for obvious reasons, but this is Jeff Koinange Live. Tonight, two lawyers, two very different perspectives, and we're talking everything from the draconian media bill to the state of the judiciary to the ICC, that elephant in the room. It's time to ask some very tough questions, and you know it is time for Jeff Koinange Live. And I said we are live inside the Intercontinental because it is pouring down outside, but the show must go on. And tonight, a show you must listen to, because these are the signs of the times. What's going on in the executive? They're issuing orders, and then the Supreme Court slams them down. We're talking everything from the judiciary to the media bill, and yes, the ICC. Two guests, one of them is still on the way, probably stuck in traffic. We'll get to him as soon as we can, but we'll talk to the first one. He has, for the last 5 years, been the executive director of the International Committee for Jurists, Kenya chapter. He's just literally come back from The Hague, where the ASP was holding, the state parties were holding a very important summit in which some very important decisions, or maybe not, were made. George Kegoro is here. He showed up early. We're going to talk to him until the other guest shows up. George, good to see you. Good to see you. Thanks for making it on time.
Thank you.
The show waits for nobody, George. We go on.
That's fine with me as well.
Okay. This empty space here is for Abraham Korir Singoe. Whenever he shows up, we'll put him on. In the meantime, you've literally just come back from The Hague.
Yes.
And there are a lot of people out there waving a flag saying that they won this round. That yes, the spin that's coming out is that Kenya, the case against Kenya, was a huge success. Your thoughts?
I think you've got to understand what was going on at The Hague, what the Assembly of States Parties was all about. The Assembly of States Parties is an annual meeting of states that are parties to the Rome Statute, or that is the law that establishes the International Criminal Court. Every year for the last 12 years, they meet annually. And that is the top political organ of the court, and they meet to discuss issues to do with the court. They meet to elect judges. They meet to elect other officials like the prosecutor.
But this year Kenya dominated, didn't it?
Correct. So this year, and I was coming to that, the reason why Kenya dominated this year has got to do with the activities that preceded the ASP itself. In October, Kenya convened an extraordinary summit of the African Union in Addis Ababa, and the states parties to the African Union resolved that they were going to support Kenya's request to the Security Council to defer the Kenyan cases before the ICC. The Security Council issued its decision. It was in the end a vote by the Security Council rejecting the deferral, and the consideration by the Security Council were to the effect that since the court had shown some flexibility in the management of the first Kenyan trial, the one facing the Deputy President William Ruto, then any issues dealt with at the Assembly of States Parties, the ASP. So that immediately transformed the ASP, which would have been an ordinary routine meeting, into an important meeting in terms of the interests that Kenya was trying to advance through the AU and through the Security Council. So basically the Security Council pushed the matter off its plate and into the ASP, and that is what turned the ASP into such an important meeting for Kenya and for the African Union. Now, when the before the ASP began, the African Union requested that there should be a special segment to discuss the the African Union position that no head of state should be put on trial while in office, and that if there's a trial for a head of state, this should be made to wait until the person leaves office. There was a long discussion, 6 hours, of that position, and they had these independent presenters and independent presentations as to what the position should be, whether a head of state should be put on trial. They had Professor Sherif Bashuni, who is a renowned international lawyer, and Professor Charles Jallo making presentations. In the end, the consensus in that discussion was that as far as international law is concerned at the moment, it is not possible to give a head of state immunity because the international law has moved very significantly for the last 50 years away from that position.
Okay, but the other thing they were going for was the fact that the president doesn't have to appear on February 5th or at all, and he can get an excusal. And if he has to take part, he does that through video link. They got the video link.
Yes.
And they got the excusal, but it has to go through the lawyers each time? Is that
Kenya's security, when the deferral at the UN Security Council failed, then the second attempt, the second next position would be to have a situation where the president should not be tried while still in office. When that was not welcome, and one of the things to be said is that at the AU in Addis Ababa, the states were very strong about saying presidents should not be tried while they're still in office. When they came to the Assembly of States Parties, the African states that spoke very strongly about that, they were a lot less strong in the way they presented their position. In fact, they prevaricated a lot and said, let's talk about it. States like South Africa, which were very strong in Addis Ababa, at The Hague, they were no longer as strong, and they were saying, okay, if we need to discuss this, so they were open-ended about their position.
So
that
Kenya's that unity they left with in Addis,
yes,
wasn't present, wasn't evident.
That was not evident at the ASP. Then the next best option for Kenya then would be to have a situation where, if a trial has got to go on for the president, to arrange it in such a manner that perhaps he does not have to face the trial. The whole idea about presence in court. And now that is the situation in relation to which the assembly was prepared very, very strongly. There was very strong sympathy within the assembly for Kenya's position. That is the truth.
Right.
The idea that the president should not have to face his trial resonated significantly. Should not have to spend time at The Hague while facing trials. Resonated significantly with the assembly.
Right. But come February the 5th,
yes,
the day of the start of the trial,
yes,
does the president of Kenya have to be present in person?
Yes, and there is a good reason for it. The amendments that were made, which was an amendment to Rule 134, or which are rules of court. You see, you've got the Rome Statute, which is like the constitution of the ICC. The statute says at Article 63 that when an accused person must be present in court during trial. Now, the rules of court, which is what they were amending at the ICC, have got to comply with the statute itself, and they amended the rules to the effect that video technology could be used as a substitute to presence at trial. Mm-hmm. They also said that if a person has extraordinary responsibilities at national level, then consideration can be given to excusal, but they left all that to a decision by the judge. Kenya at one point was pushing for an automatic excusal, but that would have been more offensive towards the Rome Statute. It would have offended the statute itself. Right, so the short answer is the judges could possibly give the president a reprieve from continuous presence at trial, but he has to. They've got to make that application either before February or otherwise. But the position right now is that he's got to be present at trial unless the judges excuse him. And
are we going to use the same three judges? Is it Osuji and the other two?
Yes.
It's the same three?
Yes.
So they rule whether he will continuously be present?
Correct.
But he has to be there on February the 5th?
Unless it is possible for an application to be made before that, and for a position where he doesn't have to be present to be procured through such an application.
Yeah.
But unless that happens, then he's got to be present on.
What if he says, I'm not going?
that is a different matter, and I don't think he has said he's not going. I think people around him have said that he shouldn't go. The AU itself has said that he shouldn't go, and has a formal resolution and formal position to that effect, but he has not himself said that he's not going.
What if those... We're going to block the runway. We're going to bring 1 million people to the airport. We're going to block the runway.
Those are those people, but those are not himself. that is everybody other than himself. I think he has individual responsibility for whether or not he attends his trial, and I'm sure that is something that he and his lawyers would be able to work out.
If you were advising him, George, you're a lawyer, if you were to advise him about this one day, show up on February the 5th, stay 1-2 days, show up, show them who you are and tell them you are not guilty. Would you, is that the advice you'd give him?
I have a documented personal position that is the best possible advice. Kenya is a rule of law country. We expect that our ordinary citizens, when faced with rule of law situations, that they will respond in a manner that is expected by the law. So the president, as the leader of the country, it would be a good thing for him to set an example that is supportive of the rule of law. So my personal advice to him would be he would need to show up, because then it supports the aspirations that we have as a country, as a law-abiding country. Secondly, the Constitution and the AU, this also became apparent at the ASP. The AU Kenya has pushed a position that the president should not be put on trial while still in office. Now, that position is at variance with Kenya's domestic law. The Constitution of Kenya says that if the president is faced with a crime, with a situation that is a crime under an international treaty, then immunity does not apply. So what the AU has been pushing Kenya to do is to contravene its own constitution. Now, if that happened, obviously, then if the president did not attend his trial, and he has not said he's not going to attend his trial, then obviously what that means is that it creates a very difficult and confusing internal situation. Should other people then also, who are also facing trial in domestic courts, decide that they can't go for their trials? And if they decided that they can't go for their trials, what authority or what justification would authorities have for arresting them or doing anything about it? So it's got those types of issues domestically that have got to be considered very carefully in whichever decision the president makes.
Tell me something, George. Does all this apply to the deputy president as well?
The deputy president is already on trial. He is cooperating. He has cooperated so far. I think he's been a very good example of a top citizen. Sitting quietly in court when he's required to do so. So he's been a model defendant. So I imagine that the discussion that is going on relates to the president more than to the deputy president, because the deputy president's case has begun and is already cooperating, and he goes for his trial.
And the other thing is, George, he keeps saying, I want to go the whole hog. There's a lot of signals coming out of the ICC with the deputy president's case. He wants to go the whole hog. He wants to see it through for some reason. So there's a divide, if you will. The presidency is saying one thing, they're trying to prevent their man from going. Deputy president, he says, Kiumane.
Okay, I don't know. Maybe that's I don't know anything about the internal politics within Jubilee, and of course, what happens is if the deputy president's trial is going on and the president's trial does not materialize for any reason, there could be political discomfort within the government around that. I don't know.
George, you're a lawyer. You know this, man. You can see it. You can see it better than I can.
I don't know. Lawyers are not politicians, so I can't read the politics. My guess is that it would be like I think within government and within the Jubilee coalition, there might be people with positions to the effect that what is good for the goose must be good for the gander, and so on and so forth. But there would also be others within Jubilee, including in the deputy president's fold, and I think I saw a bit of that at The Hague, that with regard to the president, we make an exception. We are happy for the deputy president to go on trial, but because the president occupies a particularly special position in the country, then we are not happy that he should attend his trial. But my own view is, when a person that has such high standing as the president then responds in a manner, responds with humility to a law enforcement situation, respect for him grows rather than diminishes. President Mandela, when required to attend court when he was president, he did, and that is part of the phenomenon that increased the Mandela magic, and Mandela is regarded among other things as a law-abiding #1 citizen in South Africa during his time.
Absolutely. George, let's hypothesize, if you will, down the line. What if one of them is convicted in the end? How is it seen here back home? Is it a split literally right down the Rift Valley, if you will?
I don't know. I mean, if these cases are at their infancy, they would take their course. If a conviction occurred, to say what the consequences politically or otherwise of such a conviction would be, I would only be speculating. So I'd rather just say that I don't know what would happen. But let's say what happens in other countries when convictions happen. I think, and all politicians who are watching know this, I think politics has a way of just, you're important when you are in the saddle. When circumstances happen, you're no longer in the saddle. Politics has a way of replacing people. So I think that is sort of the political reality.
Sure. Okay, on a scale of 1 to 10, or let's better yet, from A to F,
yes,
how would you rate Kenya's standing at the Assembly of State Parties, the way they came out, from A to F?
Kenya fought hard. I think they were very committed. They convened daily briefings for themselves. They attended every meeting. They did their own drafting of the positions that they were advocating for. When they realized that alternative positions were being advanced and those were also being listened to, they took an interest in those alternative positions. So I think the team of Kenyan negotiators did a very good job in terms of applying themselves to the mission that they had in hand.
Yeah. Would you give them a B?
They did a good job. I wouldn't want to say a B or whatever, but they did a very good job. But what is it that they were trying to achieve? They were trying to achieve that which is basically very difficult or impossible to achieve.
Yeah.
The statute says, they were trying to achieve head of state immunity, basically, although they were not calling it that.
Right.
Now, they didn't get that. That was turned down during the general discussion.
And there's no more fight. They can't go anywhere else. There's no appeal court. There's no other avenue.
That was really a political discussion rather than a change of rules to give head of state.
But this was the last resort, right?
That was sort of at the last resort to get a political position that is favorable to head of state immunity. That they did not get, although they put on a very strong case. Then the next, they were putting on a case to amend the rules so as to get excusal and so on and so forth. But the statute itself doesn't allow excusal, so they were changing rules within a very narrow allowance.
So it was like a football game, and they played a really good game, and in the end they lost 1-0 maybe.
Yeah, something like that.
Okay. George, we're going to take a break. I understand Korir is here. Okay. Let's see if we can come and debate the way we're debating. You're watching Jeff Koinange live. We are indoors today for obvious reasons, still at the Intercontinental, and we're talking everything from the ICC to the future of the judiciary, if you will, and of course that draconian, horrible media bill which the president just sent back to Parliament. Where do we go from here? Don't forget, you can tweet us. My handle is Koinange Jeff, hashtag SMS line 22155. Let's get tweeting. Let's get talking. Right now, we take a break. We'll be back in a moment. Welcome back to Jeff Koinange live from the indoors part of the Intercontinental Hotel. And yes, we can confirm Abraham Korir Singoe is in the building. Finally. Good to see you, my brother.
Appreciate it.
Thanks for making it, man. I know there's
you.
Crazy traffic out there, but, We'll talk in a minute. I know your tweets are coming. Please keep them coming. Ledama Olekina, you must be bored in America, man. You sent 3 tweets already, my brother. What's going on? All right, gentlemen, let me read Ledama's tweet real quick, and you guys can answer this one. Do you see a situation where the Kenya Parliament, Jubilee, amends the constitution to provide immunity to a sitting president? Go on. You haven't said a word in 20 minutes. Go on.
I think it's really important to say that the rules for amending the constitution are very clear. The provisions relating to presidential immunity are also in the constitution. The exception to that immunity rule relates to a situation where the president is charged, for international crimes. Okay.
Yeah.
I don't think so. I haven't heard anything. I do not contemplate that. Parliamentarians who value the national values, who value the Bill of Rights, would actually, would go through an amendment process of the Constitution.
Okay, Korir, let me ask you a simple question. We're going to switch gears here for a moment because let's talk about the judiciary and the JSC. The president goes to Eldoret late last week, and he announces that the 6 JSC members are suspended. He appoints a tribunal led by Aaron Ringera, who was rejected by the same JSC members when he had tried to apply for a job. High Court or Supreme Court here comes back and slams this and restores the JSC members. I mean, what kind of advice are you guys giving the judiciary? The executive, rather.
I think it's fair advice. The point is this. Article 251 of the Constitution is very clear. Parliament was seized with a petition relating to the misconduct, the gross misconduct of members of the JSC. The Constitution enjoins Parliament to consider that petition and to satisfy itself that there is merit in that petition. Parliament undertook that process. It determined and satisfied itself that there were issues that required determination. It recommended that the president should initiate proceedings against members of the JSC. The Constitution does not leave any wiggle room for the president in terms of setting up the tribunal. The only wiggle room that exists is the discretion of the president to either suspend these individuals during the pendency, of the tribunal process. And so this is a discretion that the president exercised to suspend them and then appoint the tribunal as required by the Constitution. George. The membership of the tribunal,
yes,
in my view, is neither here nor there.
Ringera?
Okay?
Ringera?
It's neither here nor
He's
there.
A reject.
He qualifies, he meets the requirements of chairmanship of that tribunal.
But Korir, this man had been rejected by the same members. He would have an axe to grind.
This is the JSC we're talking about.
George, was that a good decision by the president? Was that a good call?
Let me say this. I think when this thing is not unrelated to the internal problems of the judiciary, which started with the disciplinary proceedings against the former chief registrar. And while those proceedings were going on, the parliament was pursuing a different forum, created a different forum to pursue exactly the same issue, which was in the form of questioning the legality of the proceedings against the propriety of the proceeding against the chief registrar, and making a very strong and extremely public case that they were going to hold the Judicial Service Commission accountable for what it was trying to do to the chief registrar. So basically what happened is that there was a political mobilization to address what was an internal disciplinary issue within the judiciary.
But
that was the problem.
Right.
And then after that, it has gone worse at every turn.
Absolutely.
The Legal Affairs Committee and the Parliament mobilized itself to go through a hearing which clearly had a predetermined outcome, and having had that outcome, they set up the president to either appoint or not appoint a tribunal. Now, the Constitution is in the end a document that has got to be interpreted in the context of lived political responsibility. And the political responsibility required here that everybody should allow every institution should allow the next institution the space that it requires to operate autonomously. That has failed, and the wheel has gone full circle. Every institution has played the ball in such a way that it has told the others, you can't touch us. So we've got a stalemate right now.
Korir, do you agree? Because it looks like the legislature, parliament, the executive, the presidency have ganged up against the judiciary. Is that what it's looking like?
I don't think so. I think the presidency and the executive, for that matter, has been very, very clear in terms of honoring the principle of separation of powers. Okay? Giving the judiciary its due respect at every instance. The president is enjoined by the Constitution to act on a petition by Parliament. He has no rigor room, and that's really the argument that we're making here. And so the membership of that tribunal, one can question, their suitability, and that's a different question. But as to whether the president has properly exercised his authority under the Constitution, there can be no question.
Okay, where does this case go now? George, where does this case go now?
It's not easy to see where this case goes now, and all this that question could have been avoided. That question that doesn't have an obvious answer could have been avoided if there had been better counsel on the part of everybody at every turn where this matter has traveled. The president had a choice to appoint the tribunal or to mediate or to and I personally
it's nowhere in the law. You see, the president would have to operate outside the legal framework in order to engage in the process that George is describing.
So you think he was within his right?
Absolutely. Absolutely.
What has been happening here is there's a political direction that is clothed in a very mechanistic reading of legal processes, and that political direction could easily also have been clothed in differently, which would have allowed for a discussion between and among all organs involved, so as to achieve a more responsible outcome.
Has the judiciary been left in disarray because with 6 members out of action, but they've been restored right now? The daily functions of the commission cannot go on. There's an impasse right now.
Well, happily, the court has intervened. Okay, the court has intervened, and I believe that the executive, as an institution that respects the rule of law, will abide the court decision, during the interim period while the matter is being determined inter partes. Yeah. And so the executive will make its case and argue before the court.
Okay, as a legal advisor to the executive, does the president eat some humble pie on this one? Does he say, you know what, you guys are right, this is the Constitution, I gotta abide by it? Does he eat some humble pie and we move on?
I think the challenge, in my view, really, is the Constitution. It's the letter, it's the spirit of the Constitution. On the one hand, often we see that the president has not acted in full compliance with the Constitution and speedily. In this instance, the president has done exactly that. Why would he be judged for doing the right thing? Okay, so the challenge here is, again, the nature of the institutional arrangements that we have created. Okay, so one would then ask whether perhaps it's time to begin to re-examine the entire institutional architecture so that we can put in place mechanisms, to address this kind of conflicts.
Yeah. George, these legal advisors to the executive, are they giving their bosses bad advice?
I would, Korir is my friend. I wouldn't like to say on television that he's giving bad advice because I think we all need the jobs we have. I would just say this. I think the whole thing could have been handled differently, and it could have been handled in a more political. You see, what happens is when you invoke formal rules, you create precedent, you create convention, which is very difficult to then run away from, and which excludes a common sense mediation of everyday problems. Now, that is what has happened here. These are all people who ought to work together for the public. Right now, the public is one that is suffering once you have this impasse. If in the first place they had a more everyday approach to what was in the end a small problem in the judiciary, then we would not be here. And I believe myself that the chance to do that has not been removed.
Okay.
What can happen to solve this issue very easily would be for Parliament to withdraw the petition that they filed before the president, and then for everybody to mediate, because the judiciary will not allow, by all accounts, will not allow this issue to go forward the way the president wants.
That's the best case scenario according to you. Korir, best case scenario with this particular instant. What would you say?
I think it's actually difficult to conceive a best case scenario, but again, whatever scenario we are thinking about, has to be sort of extra legal. It's slightly outside the contours, of the Constitution. Okay, and so if we are saying that, peradventure we are caught in a difficult situation, it might be feasible to again engage in a political process and to revisit these issues. But again, as a lawyer and as someone who honors this Constitution and struggled for it, I'm a little constrained to find space, for the kind of mediation that we are talking about at this point.
Yeah. But as it stands right now, the JSC members can go back to work. Is that what it is?
That's what the court has
the
determined.
court said they can go back, and they may have gone back. I think I understand that the Chief Justice may have called for a meeting of the JSC, I guess, for them to reassert the fact that they're back in business, and so on and so forth.
So there's really no crisis, as it were, because the court and the system's supposed to kick in just like that. There is a crisis. The court has provided some kind of way forward. I believe the executive will honor that court decision. So the process is underway, and the matter will go on being heard. The arguments will be made in court, and the final determination will come out, because this is just an interim determination that has been made.
Yeah.
Okay.
But I mean, the point is, the crisis is this: that you've got this sort of cloud that hangs over everybody, because nobody knows who has the final word around what is going on, because the president and the legislature have got contrary intentions and contrary objectives around on how to solve the issue from the position that that the courts have taken. But everybody is acting in own protection, in own interests, and without necessarily regarding what the public interest is in the whole matter. I think the public interest requires that before officials act, they consider what their actions will be for the larger public. It is not nice for the public watching this to sort of be told that people complied with the law, even though the results of their actions have created paralysis on the part of the institutions of governance.
Can we switch gears real quick? And we're going to go to a break very shortly, but let's switch gears. And now the media bill. Another very contentious issue, and the executive, Parliament sent a bill to the president tossed it back to them, but it was differently framed, in that the independent tribunal that was supposed to be formed now reports directly to the executive. That's going back to one-party rule. That was more draconian than the original bill. Korir, what advice are you guys giving these people? I mean, that's worse than the first time.
I think, let me just say the following, that it's actually wrong, the manner in which you have characterized this bill as draconian. I have had the word draconian used so intensely over the last 1 month that all of us now believe that everything around this bill is draconian.
It is draconian.
Just because of a tribunal, which is supposed to be an oversight body.
Independent.
An independent tribunal, that is supposed to be an oversight body over the media. All right? And just by virtue of that, we have characterized the entire intent of the bill, to be draconian.
Yes.
I think we miss so many good things about the bill, because in my view, if Parliament disagreed with what the president has said, they can change that language. Okay, they can they are Parliament. They can revisit the question. They can change the language for it to be consistent with with the Constitution and with the political imperatives that drove the need for the bill in the first instance. All right,
Korir, what is wrong about the president? This independent tribunal we're talking about, right? What is wrong with it being independent? Yes, they can have someone from government. Yes, they can have someone from, CCK, post of wherever. But it's not the president or the cabinet secretary who appoints this tribunal, who appoints these individuals. Right. Why can't we be independent? I know we're not perfect. We're far from perfect. Why can't we be as independent as possible so we don't have to answer to any of these institutions?
I think that's the whole point, because I think the question of independence here is really important, because whenever we talk about independence, we mean it, okay? We mean it, and the Constitution says very clearly that the institution that is supposed to be set up as an oversight body over the media should be independent of the media itself, of the executive, as well as of government, as well as of commercial and private interests, okay? Yeah. All right? And so what this bill has attempted to do is to craft that independence, okay? It's attempted to craft it. Perhaps if it's not perfect, that's the role of Parliament to clean that up.
George,
okay?
Korir says it's draconian. Oh, it's not draconian, rather. He refuses, he doesn't like this word draconian. What are your thoughts?
I think, Jeff, the first thing is to congratulate Parliament, which today, throughout the Public Benefits Organization bill, the amendments that were supposed to be done to the PBO Act, that happened this afternoon, and that's a good thing for the country. But that bill and the one we are discussing now have one problem in common. There's a clear procedural issue around how government is running its legislative program. There is significantly insufficient consultation going on before legislative measures are brought to the National Assembly, and all stakeholders are seeing for the first time things that affect them very directly when a proposal to pass a law has been made. That is true of how the PBO has been processed. That is also true how the law on the media has been processed. There simply hasn't been sufficient consultation with the stakeholders, as would allow everybody to identify the problem that the law seeks to resolve, and the best manner in which to resolve those problems. And the difficulties we have with the media amendments is at one level that. Now, another level of the problem, and that reflects that the first level, is there hasn't been agreement in this country yet as to what would be the ideal model for media regulation. The president, through the amendments he suggested, he came up with his own model, which was crafted all in the space of maybe 2 days.
Correct.
when he had to.
And Parliament, if they don't pass this, if they want to revert to the original, will have to pass it by 2/3 majority. Is that the case?
Yeah. Yes, that's the case, and I was going there. Now, the Parliament has its own model for media regulation. The media have with their own disparate models as to how media regulation should be undertaken in this country. Yeah. And there hasn't been a process where everybody sits together to say this is the best way to regulate media, and these are the reasons for that.
Okay, Korir,
so that is missing.
Okay, good.
Absolutely.
I know you want to jump in, Korir. Hold on. We're going to have to take a break, my brother. When we come back, let's take it right from that point. And also, are we going to lose the freedoms that we have right now, Korir? At the end of the day, that's what we want. We want our freedoms, but yes, we need checks and balances, but not by the executive, not by these folks down here. Let's take a break. Come back. Please keep the tweets coming. Hashtag is JKL. My Twitter handle at Koinange Jeff. SMS line is 22155. You are watching two hot lawyers, folks. Oh my, what my? They know their stuff. Keep it right there. Don't even think of touching that remote control, because you know we are back talking sense in a moment. Welcome back to Jeff Koinange Live. I tell you folks, what a conversation we're having, and keep those tweets coming because they are no doubt coming in thick and fast. With me today, if you're just joining us, is the legal advisor to the Deputy President, Abraham Korir Singoe. He also was once a lawyer for the MRC, Mombasa Republican Council. Go figure. Right next to him, Executive Director, Kenya Chapter, International Committee for Jurists, George Kegoro. Gentlemen, a couple of tweets that just come in. Pumba saying, if this Korir guy is the one advising Uhuru on JSC and media, he should be relieved of his duties without delay. That's a little unfair, and I agree, but listen to what they're saying about me. We finally know who stole Cristiano Ronaldo's hair gel. Kim, what? Pay attention, man. Gentlemen, moving right along. You missed the first conversation in the first part of the hour about ICC, and you are the Deputy President's legal advisor on the ICC. And he's been pretty compliant so far. I mean, he's been showing up when he was supposed to show up. He's been playing ball, if you will. Now the President has to show up on February the 5th. And you heard what happened at the Assembly of State Parties Korir. Your thoughts? Was it a victory for the presidency? The video link, the excusal, even though they have to apply for each time, was it a victory?
You know, I think it was a very, very important step. For the reason that, you know, before the adoption of Rule 134, it's called there are three basic rules, okay? Before the adoption of that rule, the only provision that we had was the Rome Statute, which talked about or required an accused person to be present at his trial. All right?
Yep.
Now, we have seen through the trial of the Deputy President some measure of excusal taking place. Almost an expansive interpretation of the Rome Statute. There has been no specific rule in the rule book that will facilitate actual excusal. So what we were able to achieve as a country was Rule 134. And Rule 134, yes, it has this video link. Actually, Rule 134 now provides that physical presence, or rather presence
continuously.
No, presence within the statute does not mean physical presence alone, okay?
Yeah.
Presence includes video presence, okay? So you can be present through video link. Okay, secondly, and more importantly, there is now a very clear provision that if you are engaged in extraordinary duties, you can appear in court solely through counsel. Okay?
Okay, but February 5th, 2014, the beginning of the trial of the President of the Republic of Kenya, he has to show up physically. Is that so far? It looks like he has to show up physically?
Not necessarily. Not necessarily. For the reason that, you know, and I believe his lawyers will be doing this very shortly, you know, that they will be basically making the argument before the court right now, way before the 5th of February, that the President will appear either through, you know, video link, or that they would be representing the President, you know, in those proceedings.
But George insists he has to show up.
What I said, Jeff, is if the President is excused from attending his trial, then he doesn't have to go. If the judges do not excuse him from attending his trial, then he's got to go. So what I said is what was achieved through the rules is a procedural basis for the possibility that the judges can excuse the President from physical presence. But as to whether or not he has got to be physically present, the Rome Statute requires that he's got to be physically present, and the rules themselves provide that that whether or not he's excused from physical presence is a decision for the judges.
Korir, let me ask you this. I know you want to comment, but let me ask you this real quick. Deputy President, he's been playing by the rule book, and he says he wants to see this through. He wants to go the whole hog. It seems like there's a different signal coming from State House itself. And basically, they don't want the president anywhere near the ICC. There's a different rule book, even though you're all on the same coalition.
I don't actually agree. I think from the word go, both His Excellency the President and the Deputy President have made it very, very clear that they want to obey the law, okay? However, one of the big challenges and one of the big balances they have to deal with is that both the President and the Deputy President do not want to countenance a situation. They do not want to brook a situation where they would be unable to provide effective governance to the people that elected them, okay? That is the struggle, Jeff. And it's not an easy struggle, okay? So every measure, and you've seen the Deputy President indeed cooperating with the court, but there has been every attempt to make sure that this process continues without impeding the capacity of the President and the Deputy President to discharge their constitutional responsibilities. And that is the struggle, and that is the balance. Nobody is talking about immunity from prosecution.
Okay, let me ask you this, Korir. With the ASP, it seems like all that was geared toward the president. What happens to the Deputy President, who you advise? Does he continue with this trial all the way, or is he also part of this excusal and video link and all this? Is he part of that?
Absolutely. Absolutely.
So he doesn't have to show up come next year?
The point that I have made is that the rules now require, okay, or the rules now provide that if you are an individual who exercises extraordinary responsibilities of the state, and that includes the president, it includes the deputy president, it could include a prime minister, a military leader, etc., etc. If you are a person within that category of people, okay?
Yeah.
You can be represented by counsel, and the matter, your case, the hearing of your case would be able to proceed unimpeded.
George, so that means at the end of the day, the only person who will be tried at the ICC, if this goes through, is Joshua Arap Sang, the only one who will be physically present at the ICC.
Not necessarily. All these rules are subject to two important provisions. First, the rule itself recognizes that the decision whether or not you're going to be present at The Hague, the ICC, is a decision by the judges themselves. The states didn't make that decision. The drafting, and there were many drafts. Kenya proposed a draft for automatic excusal, and that was not accepted by the states parties. So there isn't an automatic excusal. An application would have to be made to the court, and Korir himself has said that his lawyers at some point would have to make an application to court, and the court must make a decision. So one possibility is that the court will decide that the president or the deputy president don't have to go to The Hague physically, and in that case that will be the situation, and a trial can go on in their physical absence.
Okay.
But also, in deciding whichever way they do, the court must give heed to Article 63 of the Rome Statute, to which the rules that have been amended are subordinate, and which they are not allowed to contradict, and which requires physical presence in court.
Okay, those were your last words, Korir. You get the last word now. What do you say going forward? How do we deal with this monster in this room? Will we ever get rid of it? Because you look like you haven't slept in months, man. You look like you have a tough job. And I mean that with all fairness, my brother. Going forward.
Well, in terms of the ICC process, I think as a country, this is a huge burden on our leadership. What Kenya has tried all along, as a country that obeys the rule of law, what we have tried and what the leadership of this country is attempting to do is to comply with our obligations internationally, but without shirking, without failing to discharge fully the mandate upon their offices. And that for me is the understanding that Kenyans should have. They should be able to appreciate the challenges that both the president and the deputy president are having in terms of going forward with these trials, but at the same time providing service to the people of this country. None of them, and I must say this, none of them is willing to allow this process to compromise the dignity and the strength and the unity of our country.
Gonna have to leave it at that, gentlemen. But in the meantime, try and advise these guys. But this is just from a guy who's not even a lawyer, because, like George said earlier, it's like giving this president a suicide pass in rugby every time. The judiciary, slam. It's like you're waiting to slam this guy at every turn. You guys, that's all I can say. Korir, good to see you, my brother.
Thank you.
Thank you for coming over. We're gonna have you over soon again, George.
Thank you very much.
Your time. I know you're a busy man. You've had a busy year, but thanks for making it to JKL. You've heard these two lawyers, folks. I know we're going to have them back another time because they are making sense with what they say. Keep those tweets coming at Koinange. Jeff, are you on Twitter? What's your handle?
Singoe for Kwanzaa.
Singoe for Kwanzaa. I saw that the other day.
It's George Kegoro.
George Kegoro. You heard that. Tweet us all. Tell us what you think. Forget about the hair gel, okay? In the meantime, Jeff Koinange Live continues tomorrow. It's a show you don't want to miss. I've got Daddy Owen, Deno, Henry Wanyoike, amongst others. We're talking real issues. That's going to happen tomorrow going forward. In the meantime, the news continues with Yvonne Okwara and Wilson Buru right here on Kenya's television network, KTN. Thanks for joining us. Good night. Good luck.